Hi dear students, welcome to our online classes. Hope you all are doing well and fine. Today I'm with you to discuss about few of the important topics in business law. In this regard, let us discuss about agreements with minor and exceptions. The topic today is, I'm mentioning few of the important points on the screen here for you to look at it for a more better understanding. Minor and agreements. Please excuse me for my typo errors because I'm just simultaneously typing as well as explaining. I may do some typo errors. Please excuse me for this. So, who is a minor? According to Indian Contract Act ICA of 1872, Section 11, it explains certain requirements of the minor to be fulfilled with certain exceptions before entering the contracts. And a minor is a person who is below the age of 18 years. And according to ICA 1872, a very important legislation in the field of commercial law described basically the responsibilities for regulating the contractual relationships with few obligations. So, a common legal complexity often arises when we make agreements with minors. And this also causes problematic because this act does not permit such agreements outrightly. Hence, Section 11 of Indian Contracts Act explains the requirements of competency for entering into contracts. Individuals or any business entities who can create the contracts only if they meet these requirements. And the very first such requirement is majority of age. Majority of age is the primary requirement to be fulfilled as per ICA to enter into contracts. Important point. So, the general rule of contract is that every person, whether natural or artificial which in terms a company, can enter into contractual obligations. So, Section 11 lays down certain exceptions. For example, minors, the persons of unsound mind, and those whom the law specifically disqualifies, with certain exceptions. In this regard, the rationale behind Section 11 is that all the parties to contract must be competent. So the first point is all the parties entering into contract must be competent with sound mind. And coming to agreement with minor parties, Section 11 states that only persons who have attained the majority according to the law are competent to make the contracts. Therefore, there must be a law that defines the age of majority. In India, the Indian Majority Act of 1875 declares the age of majority of all the persons to be 18 years. So, Indian Majority Act of 1875 declares majority at the age of 18. The next important point. And one of the prominent case which describes or explains this issue is Mohiri Bibi versus Dharmadas Ghosh. Important case name is Mohiri Bibi versus Dharmadas Ghosh. the case facts are, in this case, a minor borrowed some money from a moneylender by mortgaging his house. I request all the students to be attentive in listening this case fact. I repeat, in this case, minor had borrowed some money from a moneylender by mortgaging his house, and the moneylender moved to take possession of this minor's house when he defaulted the payment. Hence, the court, however, said since an agreement with the minor parties is void, the moneylender could not enforce this contract. Indian courts have repeatedly used this judgment to save the minors from contractual obligations. Hence, minors cannot enter into agreements unless some legal provisions allow them. So, hence, the above case proves that minors cannot enter to agreements unless some legal provisions allow them. And generally, when we talk about the rules relating to agreement with minor parties, very important, students. Please look at the screen for the important points. A contract with minor is void. So, no obligations can ever arise on him. He is protected by the law. Then, minor parties cannot ratify the contract upon attaining majority unless a law specifically allows this. Then, third one, no court can allow specific performance of a contract with minors because it is void altogether. The Partnership Act also prohibits minors from becoming partners in a firm. And last but not the least, parents or guardians of minors can name them in contracts only if it benefits them. But even in this case, the minor cannot be personally liable. And let us see the exceptions to this above. There are certain exceptions to the minor agreements, like for the necessaries. For example, like in most of the states, a minor cannot void a contract, especially for necessaries like food, clothing, and lodging. So, when a minor makes any contract, purchases some provisions from a shopkeeper and without paying money for it, however, he is liable to repay the money to the shopkeeper once he attains the age of majority or attaching to his personal property of the minor. These are the only exception for the minor contracts is necessaries, which relates to his food, clothing, and lodging. I'm sorry, it's not gold, it is food. So here we are ending the contracts with minor.